April 2nd, President Trump determined that our exploding trade deficits had brought us to the brink of an economic and national security catastrophe. He further pronounced that the traffic of fentanyl and other opioids into our country has created a public health crisis, taking hundreds of thousands of American lives. President Trump has declared that these emergencies are country-killing and not sustainable, that they threaten the bedrock of our national and economic security, and that fixing them will make America a strong, financially viable, and respected country again. Due to IEEPA tariffs, President Trump has negotiated agreements worth trillions of dollars with major trading partners, including most recently China. Unwinding those agreements, he warns, would expose us to ruthless trade retaliation by far more aggressive countries and drive America from strength to failure with ruinous economic and national security consequences. In Dames and Moore against Regan, this court held that IEEPA's sweeping and unqualified language grants the president's actions the strongest presumption of validity and the widest latitude of judicial interpretation. Yet plaintiffs argue that tariffs, IEEPA's least blunt and most nimble tool, are virtually the only tool that Congress did not grant the president to deal with foreign emergencies. That is wrong. The phrase regulate importation plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. And plaintiffs concede that IEEPA authorizes quotas and other tariff equivalents. The major questions doctrine does not apply here. IEEPA confers major powers to address major problems on the president, who is perhaps the most major actor in the realm of foreign affairs. And the non-delegation doctrine casts no doubt on IEEPA because Congress may assign the president broad authority regarding the conduct of foreign affairs, where he enjoys his own inherent Article II powers. I welcome the court's questions.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas, and I maybe make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine, and that's for at least 2 reasons. First of all, just as a matter of kind of common sense interpretation, one would expect Congress to confer major powers on the president to address major, sort of international crises, so to speak, in foreign arising emergencies, that's just sort of a natural common sense thing you expect Congress to do. And in fact, Justice Jackson in his Youngstown opinion addressed this very situation in pages 652 and 653 when he says, this is the system within this is the procedure within our constitutional system that we have developed to strike the balance. What Dames and Moore described as the never-ending tension between the need for the executive to have robust powers to address emergencies and to subject it to checks and balances. What our constitutional system has devised to address that particular problem, that never-ending tension, is the system where Congress confers broad and necessary powers in advance and subjects them to ongoing political oversight, which is exactly what you see in IEEPA. So that's one reason. One reason, just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president, who has his own broad range of major authority,